Generally, a mortgagor of real property may sell or assign its rights in the mortgaged property to a buyer unless the promissory note states otherwise. The buyer may take the property subject to the mortgage, under which the buyer has no personal liability for the debt and the seller remains liable. Or the buyer may take the property by assuming the mortgage, under which the buyer becomes personally liable for the debt and the seller remains secondarily liable as a surety. But what if, after the sale, the buyer and mortgagee make a material change to the mortgage's terms without the mortgagor's consent? Is the mortgagor still liable? The Indiana Court of Appeals considered this question in Federal Savings and Loan Association of Gary v. Arena. On May 26, 1965, Michael and Grace Arena received a loan from First Federal Savings and Loan Association of Gary to purchase real property in Indiana. In exchange, the parties signed a promissory note and First Federal received a mortgage on the property. Nearly 1 year later, the Arenas received a cash advance from First Federal and executed a second note and mortgage. Under a reservation of rights clause in the mortgages, First Federal retained the right to deal with successors in interest in the same manner as it did with the Arenas. On March 10, 1969, the Arenas sold the property to Sanford G. Richardson, subject to the two mortgages with First Federal. That day, without the Arenas' knowledge or consent, Richardson and First Federal signed a modification and extension agreement. Under the agreement, Richardson assumed both mortgages, extended the payment period to 20 years, and agreed to an increase in the interest rate from 6% to 7.25%. On June 27, 1975, Richardson defaulted on the mortgages. Subsequently, First Federal brought a foreclosure action against the Arenas, Richardson, and others in state circuit court. In response, the Arenas moved for summary judgment, arguing that they weren't personally liable for the debt. The court agreed and granted the motion. First Federal appealed to the Indiana Court of Appeals.